this reform of the sector was already in train, and I'm delighted that we're going to get it through the House tonight.
I call the honourable member Raymond Ho. Ni hao ma.
Ni hao. Thank you very much, Mr. Chair. Following the good spirit of the Minister who has just resumed his seat, I'd like to acknowledge the Honourable Shane Jones, the Labour spokesperson for Building and Construction. He was experienced Minister for Building and Construction, as the current Minister just acknowledged, and I am lucky to be his associate and to be his understudy. And also I'd like to acknowledge the current Minister for Building and Construction. And I should say that the more I've got to know about the issues involving building and construction, the more I appreciate the complexity involving the Building Act review. And I do feel for the Minister for Building and Construction, especially whenever he was accused of taking a piecemeal approach for various reasons, as just he outlined in his contribution. But that doesn't mean that he's exonerated. Last but not the least, I'd like to thank the officials. Their thorough analysis, their thorough departmental report, and their advice are very, very helpful. The departmental report on this particular bill, Building Amendment Bill number 4, is one of the best in this kind. And the departmental report, and indeed the Building Amendment Bill number 4 itself, covered a number of issues, and some of them are outside of the scope of this bill, but a very important part with regard to the Building Act review. Labour supports the Building Act review, but our position remains the same, that we cannot, at least at this stage, we cannot support the passage of this bill. Two events would have played a certain role in affecting our position, as stated in our minority report, that given the range of serious issues that have been raised by the submitters and the fact that the government would be considering the report of the Canterbury Earthquake Royal Commission findings, it would make more sense to separate off the elements of the number 4 bill that related to dams and hold back the provisions that deal with the consumer issues in relation to residential properties. If that happened, as indicated in our minority report, we shall have no problem in supporting the provisions in relation to classifiable or referable dams. The second event is related to the review of the non-ductile column buildings built between 1982 and 1995 with 3 stories or more. The purpose was to establish if there were any buildings with similar design flaws to the Canterbury television building which collapsed in the February 2011 Christchurch earthquake, killing 115 people. I should say the approach taken by the Minister was sensible and professional. There are 2 building owners who have refused to engage with the review despite the council asking them to get an engineering assessment. The status quo does not give councils or the ministry the power to compare at-risk building owners to have their at-risk buildings assessed and their problems addressed. And I agree with the Minister who found it unacceptable, and I understand he has been investigating options to increase accountability. The options the Minister is investigating or was investigating or is investigating are either a SOP to this bill or a standalone legislation. If the Minister has introduced such a SOP, it may affect our position with regard to the bill in its entirety. So, Mr. Chair, it is more in sorrow than in anger that we have no other choice but to decide to vote against this bill. Having said that, I should reiterate that our position, as stated in our minority report in the Building Amendment Bill number 3, now 2012 Act, has remained the same as well. It is the opportunity lost that the Minister has so far taken a piecemeal and uncoordinated approach. And I do, Mr. Chair,
I call the Honourable Member Raymond Ho.
Thank you, Mr. Chair. I do find the Minister's explanations to some extent acceptable. However, I'm not quite sure how many stand-alone bills the Minister is going to introduce or when he's going to introduce, for example, Building Amendment Bills number 5, number 6, or number 7. It sounds like the Minister is competing against Steve Jobs in releasing iPhones 5, 5S, 6, or 7. But the building sector needs certainty. And we legislators need to look beyond the status quo to introduce effective measures to prevent a repeat of the man-made leaky building saga and to prepare us for rainy days, both in literal and figurative sense. Mr. Chair, there are some other issues I'd like to touch upon at this committee stage. The first one is related to weather-tight homes resolution service. The number 4 bill states that owners of dwellings that suffer from building defects that are not remedied by the liable parties can seek redress through arbitration, the weather-tight homes resolution service, or the courts. These courses of action are already fully available to aggrieved owners, but certainly in the case of the courts and even the weather-tight home resolution service, they are ruinously expensive. This bill does nothing to reduce this cost, improve the technical ability of these judicial bodies to arrive at technically correct findings, or as stated above, to ensure that responsible parties are held accountable. Whereas the government could reasonably claim that a review of a joint and several liability vis-a-vis proportional liability, and by the way, I do accept the explanations given by the Minister in his contributions, in his earlier contributions, and the technical performance of the courts is a matter for the Law Commission to consider. The effectiveness of the weather-tight homes resolution service have formed a major part of the Building Act review, and as a consequence, this suite of legislation. Mr. Chair, the other related matter is mandatory home warranty. I support Wellington and Christchurch City Councils, 2 of our largest city councils, and a number of other submitters that have called on the government to introduce a home warranty insurance scheme and urge the Minister to refer the matter to the Law Commission for review. As pointed out by the Home Owners and Buyers Association, if responsible parties for defective building work have either gone out of the business, died, or left New Zealand, the consumer is left exposed and faces having to cover the costs. Building law should be amended to offer greater protections. Orderly, the Local Government and Environment Select Committee that considered the Building Amendment Bill number 4, now before the House to be passed and urgency, was forced to amend its report to the House. The committee and the public were led to believe that the Minister had referred the matters of both joint and several liability and the mandatory home warranty scheme to the Law Commission for review. However, the Law Commission later informed the Chair that mandatory home warranty had never been referred. For the general public, it does not matter as to who misled the committee, but I continue to urge the government to refer this issue to the Law Commission and establish a system that provides meaningful and effective protections and guarantees for consumers and consenting authorities. We must legislate to prevent a repeat of the man-made leaky building saga, especially in light of an imminent construction boom in parts of the country. New Zealand consumers deserve a protection, and the Minister needs to make sure the law ensures that contractors and suppliers will be held accountable. So, Mr. Chair, the government's piecemeal approach won't work, and by introducing inadequate measures or partial instalment is not the answer.
I call the Honourable Shane Jones.
Mr. Chair, I'd like to